Good morning. Welcome to today's meeting of the Assembly Committee on Government Affairs for the 2025 session. Will the Secretary please call the roll?
Assembly members Carter.
Present.
DeLong.
Present.
De Silva.
Here.
Edgeworth. Flanagan.
Here.
Gallant.
Here.
Golding.
Here.
Gurr. Hunt.
Here.
Jackson.
Here.
Karras.
Here.
Kasama.
Here.
Wynn.
Here.
Chair Considine.
I am here. We're all here today. This is great. Welcome to the audience here in Carson City, those joining by video conference in Las Vegas, and those listening over the internet. I would like to begin today with some housekeeping measures. First, please check and silence your electronic devices. If you are planning to testify, please sign in at the table by the door and provide a business card to our committee secretary. When testifying, please turn on the microphone and clearly state your name and any affiliation for the record. If you are providing handouts, please ensure that hard copies are available for members of the public and that electronic copies should have been submitted to our committee manager by 9 a.m. yesterday for our committee managers today. We do expect courtesy and respect in our interactions during the meeting, even if we disagree with someone else's position. And committee members will be using their laptops to view handouts and other documents. Please do not interpret that as a sign of disrespect or inattention. Today, we will hear two bills. We will begin with Assembly Bill 589, which establishes requirements to protect the privacy of certain information and genetic material. And then we will hear Senate Bill 161, which revises provisions relating to local government employees. And with that, let's get started. I will now open the hearing on AB 589. To present this measure, we have Speaker Yeager. Please go ahead when you are ready.
Good morning, Chair Considine, Vice Chair Wynn, and members of the Assembly Committee on Government Affairs. Happy day 109 of the 83rd legislative session. My name is Steve Yeager. I represent Assembly District 9 in Southwest Las Vegas, and I'm excited to present Assembly Bill 589, which establishes requirements to protect the privacy of certain information and genetic material. By way of background, I believe that Nevadans deserve the peace of mind that their most personal data is going to be protected and secured. We should not have to fear that information pertaining to our health, diagnostic findings, or our very genetics and DNA may be at risk for uses that we have not authorized. And we certainly should not have to fear that it may be used without our knowledge. And yet, this is the reality that we are facing. Our personal information is at risk, and it is my intent with Assembly Bill 589 to protect us from these risks. As you can see, Assembly Bill 589 covers a variety of grounds, all aimed at protecting Nevadans' data and privacy. I will give some brief background to explain the impetus for this legislation, and then I will take you through the bill and answer any questions. The first half of the bill relates specifically to autism-related data. Since the start of the new federal administration, people with autism spectrum disorders have faced increased scrutiny and investigation. Last month, it was announced that the National Institutes of Health would be collecting private medical records in a study of autism, ostensibly to discover its cause and cure. The announcement noted that the records consulted could include information from pharmacies and labs, insurance claims, and even data from smartwatches and fitness trackers. While healthcare studies and research are critical to our well-being, it is necessary that data be collected in the proper way, with informed consent and without self-serving agendas. It concerns me greatly that this study has emerged in conjunction with worrying, inaccurate claims regarding autism, including that it is a preventable condition. These claims have also implied its link to environmental toxins and downplayed research into genetically contributing factors. Perhaps even more disturbing, though, is the dehumanizing rhetoric that has been used by some in this administration to characterize autistic children. I'm not going to repeat those claims because I don't think that's appropriate for the record, but if you want to do your own research, our current head of Health and Human Services has made some very disturbing and I believe dehumanizing claims. Therefore, in considering the current politically motivated need for this study, the seemingly predetermined conclusions it's seeking to find, and the worrying scope of data collection, I am deeply troubled by the implications of this work and the possible impacts on our citizens. It is necessary that we not only protect their privacy, but that we also take a stand for the value that every person's life and lived experience holds, regardless of where on a spectrum they may fall. Moving forward, the latter half of the bill more specifically focuses on DNA and genetic information. It may seem somewhat dystopian to consider, but in addition to contending with threats to our personal and financial information, we are now being forced to address the sale and misuse of our genetic material. The recent 23andMe news offers a stark example of this threat. After the company filed for bankruptcy earlier this year, it announced it would attempt to find a buyer. Complicating these proceedings immensely, though, is the concurrent sale of millions of customers' genetic information. Once the company changes hands, so too could the privacy policy safeguarding customers' submitted DNA. Frighteningly, this could lead to the use or proliferation of customer data far outside its initial intended use. Customers are now being placed in the position of requesting the company to delete their data to mitigate these risks, a complication they should not be forced to shoulder alone. Even those who have not submitted DNA could be susceptible to a breach of their genetic information in the event this data is shared if they have ever had a family member submit samples. The correlation of genetic material among relatives means that the possible sale of DNA samples could have consequences for people who do not even know they are at risk. It is clear to me that as a state, we need to take deliberate steps to protect Nevadans from this disturbing new threat. I wish it was not necessary for me to be sitting here today discussing a bill to protect from dangers that no person should have to face, but it is the reality of our world right now that these threats exist, which means it is our responsibility as lawmakers to meet them head on. The people in our state are looking for us to take action, which is exactly what I aim to do in Assembly Bill 589 by implementing measures to safeguard data privacy and prioritizing ethical, sensible protections of our most personal information. Chair, if you would like, I could walk you through the sections of the bill and then take questions. Thank you, Chair. Steve Yeager for the record. So I'll walk through the sections of the bill. I'd like to begin with Section 6, which prohibits a state agency or local government or their contractors or grantees from collecting autism-related data. This section provides for certain exceptions to this prohibition, including if the data collection is necessary for the provisions of benefits, medical and specialized care, and other services to persons who have or are suspected of having autism spectrum disorders, as well as if it is necessary to comply with certain laws. Chair and committee members, there is a small conceptual amendment for this section to ensure that the Division of Insurance can handle claim disputes relating to coverage for autism spectrum disorder. And I did submit that for Nellis. We're just adding a few words to that section to make sure we're not inappropriately handcuffing our Division of Insurance. And that is the only amendment to the bill at this time. Next, Chair, Section 7 prohibits a state agency or local government or their contractors or grantees from disclosing autism-related data to outside persons or entities. This section outlines exemptions if the agency or government obtains the informed, written consent for the disclosure from the person whose data is in question or their legal guardian. Exceptions are also provided for certain legal requirements, as well as when the disclosure is necessary to provide certain services or supports. Any disclosure made pursuant to these exceptions must release the minimum amount of data necessary, and they must not include names when not necessary. Section 8 requires the Office of the Governor on a biennial basis to review state compliance to the provisions in these sections. It also authorizes the Director of the Department of Health and Human Services to appoint a time-limited advisory group to evaluate and provide recommendations concerning the implementation of Sections 2 through 8 of this bill, and it outlines the conditions for the membership and duties of such groups. Sections 3 through 5 define terms related to these provisions. Next, jumping forward slightly, Section 12 of the bill establishes that it is a Category D felony to intentionally sell or otherwise transfer a person's DNA sample as defined in Section 11 or genetic information without the person's or their legal guardian's informed consent. This is regardless of whether the sample or information was originally collected, retained, or analyzed with such informed consent. The section does outline several exceptions to this provision, including for certain investigations, parentage and identity determinations and certain diagnostic needs. Section 14 broadens existing law relating to establishing a misdemeanor for obtaining, retaining, or disclosing information used from a genetic test to determine the presence of certain abnormalities and deficiencies, clarifying that these provisions apply to any test to derive and interpret data related to genetic characteristics. Furthermore, Sections 16 and 17 make it a misdemeanor to obtain or retain a DNA sample under circumstances where it is currently a misdemeanor to obtain or retain that information. Section 18 outlines certain additional provisions related to the unauthorized disclosure of identifying information related to genetic material, as well as the submission of DNA samples or genetic material for testing without informed consent. This section clarifies that such actions are a Category E felony under Nevada law. Finally, Chair and committee members, Section 19 requires the State Board of Health to adopt regulations establishing procedures for obtaining informed consent relating to the provisions of the bill. I want to thank you, Chair and committee members, for your consideration of this critical measure on day 109 of the session. I cannot overstate how important it is that our citizens be able to rely on privacy protections for their personal health and genetic information. And it is more clear now than ever that we need to take steps at the state level to implement these protections. I appreciate your time, and I'm happy to take any questions.
Thank you for the presentation. We do have a couple of questions. We're going to start with Assemblymember Edgeworth.
Thank you for the presentation, Mr. Speaker. I think we can all agree that medical information and privacy is a really important topic. Super simple question. Are there other states that have restrictions similar to this for autism?
Steve Yeager, for the record. I believe so, and the one I know for sure, I'm hoping I'm getting the state right because it is day 109, but I think Illinois, by executive order, the governor signed an executive order related to the autism piece of this as well. So I at least know one state's done it through executive order. And then on the second part of the bill, I know you didn't ask that question, but on the 23andMe, I believe it was Alabama has recently, I don't know if they passed the legislation, but they're considering legislation to essentially do the same thing here to say, you know, you can't sell this information without the person's informed consent.
Thank you.
Thank you. Our next question is from Assemblymember Kasama.
Good morning on day 109. So if I could, Chair, I have two questions because they deal with the different sections. So regarding the first section, I completely agree we want to keep this stuff private, but help me understand, wouldn't this already be covered under HIPAA rules? Because why are we targeting just autism? Because there's multiple diseases that we're tracking that are medical information. Why would we need a separate area? Because isn't it all HIPAA anyway? So you can't disclose without informed consent?
Steve Yeager, for the record, I hope that's true. I'm a little concerned because, and I guess I'll say, I'm focusing on autism because that seems to be the focus of the federal administration right now. And I'm happy to provide some of those links, but if you search RFK autism, you're going to get more articles than you want on the topic, frankly. But I'm concerned that some of the data that seems to be trying to be obtained is like data from smartwatches, data from fitness trackers, and I think there's at least a gray area there because we think of HIPAA, that typically applies to like your actual medical records, right? What your provider has, but the efforts from the federal administration seem to be broader than that. So I want to make sure that that sort of information is covered as well. And I guess I'll say, HIPAA obviously is a federal law. I think it's probably a safe federal law, but at the same time, not really sure with what this federal administration is doing. So it wouldn't shock me if exceptions were made to HIPAA either through congressional action or executive order. So I want to make sure on the state level we have these protections.
Okay, thank you. And then in my second question regarding more of your Section 12 and the 23andMe area is in the section here, it says it cannot be transferred. Genetic information was originally collected, retained, or analyzed with such informed consent. So, for example, this company that bought 23andMe, and people, when they submitted to have these tests done for their ancestry, gave informed consent in their paperwork that they could use the information. So would this possibly subject us, if we put this in state law, to a lawsuit against our state if these people did give informed consent nationally, and now we're just putting it in one state statute that it can't be used? And I'm just concerned about perhaps a risk of a lawsuit to the state.
Steve Yeager, for the record. It's an excellent question, and I think what this provision is trying to get at is sort of exactly that, right? You might have had a contract with 23andMe, and you might have agreed to something, but with a new buyer, who knows what they intend to do with the information? So this would require, it would say, if you have previously given consent, this is going to say now that consent is not valid, and you're going to have to give consent all over again. Could that result in a lawsuit against the state? I suppose, although, that's a contractual relationship between the person submitting their DNA and the collector of the DNA. And I think the state does have the ability to enact laws to render portions of contracts unenforceable. I think they could sue the state. I don't believe they would be successful, because I think, we do that all the time. I think about in past sessions, we've actually retroactively negated confidentiality provisions that happened in sexual assault cases where, there was non-disclosure agreements that were signed, and we said it's the public policy of the state that those are unenforceable. I don't think we've been sued for that. So I think it's within our state power to say that, because really it's out of the control of either contracting party. So it wouldn't be a breach of contract. It would essentially be some kind of an effort to nullify our state action. But as a legislature, I think we do have the ability to set the public policy of the state. So I'm not too concerned about that. Litigation happens, but I think we would be in very good standing to defend that if we did get sued.
Committee members, any other questions? Speaker, I have one question, and it's about the bill, but it's not necessarily in the bill. So let's say that somebody did sign up for this company to find out their ancestry, and now they have, how would they know, or how could they stop their DNA from being sold? Like, how would they know that they could even do something about this?
Steve Yeager, for the record. So, the best example is 23andMe, just because they've been in the news, and I think there's been an effort to tell folks to make a request of 23andMe to delete their data, and I think that was part of the original contractual relationship. So some folks have done that, but I think our concern is people just don't know this is happening, right? Or they know it, maybe they hear something in the news, but they don't think about the fact that they have a profile there, or maybe a relative has a profile there, which tells everyone a lot about what's going on. So, if this bill passes, they wouldn't have to do that, right? This bill would come in and protect them so that before the disclosure would happen, the company would have to get informed consent. So I anticipate they would send emails or letters trying to seek that consent if they wanted to do it. But I do think we as legislators, I say this all the time, we do good work in this building, but unfortunately, a lot of our constituents are busy living their lives, and they don't get a good sense of what we're doing. So I think it's an obligation of ours, even if this bill doesn't pass, I think it's an obligation of ours to tell folks that this is happening. And the only thing you can do at the moment is ask that your profile be deleted. And I think you then have to have faith that that request is going to be honored.
Thank you. Seeing no further questions, we will move on to testimony. Thank you for the presentation. Testimony can be provided in person here in Carson City via video conference in Las Vegas or over the phone, and further instructions for providing testimony can be found on the agenda. We will begin with testimony in support of AB 589 here in Carson City. If anyone would like to testify in support, please step up to the table. Seeing no one step up to the table, we will go to testimony in support in Las Vegas. Is there anyone wishing to testify in support of AB 589 in Las Vegas? Seeing no one step up, AVH, is there anyone on the line in support of AB 589?
Thank you, Chair. The line is open and working. We have no callers for support at this time.
Thank you. We will move to hear testimony in opposition of AB 589. Is there anyone here in Carson City wishing to testify in opposition? Seeing no one stepping to the table, anyone in Las Vegas wishing to testify in opposition to AB 589? Seeing no movement in Las Vegas, AVH, is there anyone on the lines in opposition to AB 589?
Thank you. The line is open and working. We have no callers for opposition at this time.
Thank you. We will then move to neutral. Is there anyone here in Carson City wishing to testify in neutral? Please begin when you're ready.
Thank you, Madam Chair, members of the committee. My name is Adam Plain, P-L-A-I-N, with the Nevada Division of Insurance, testifying neutral today. We did submit written testimony early this morning, 7:15 or so. I think I saw it on the table out there, so hopefully that means staff received it. Just wanted to say that we're the agency that reached out to Speaker Yeager for the amendment on the bill. We just wanted to clarify that while we do have authority to collect some autism data under current law, the Paul Wellstone and Pete Dominici Mental Health Addiction Equity Act. We wanted to be sure that the language didn't prohibit us from collecting other autism-related data when we have a consumer complaint or we need to do things like a targeted market conduct examination for one of the players in our industry. So we wanted to thank the speaker for being amenable to our suggestion, and happy to answer any questions committee members may have about our proposal.
Thank you. We don't have any questions. If there's no one else here in Carson City wishing to testify in the neutral position on AB 589, we'll go to Las Vegas. Is there anyone in Las Vegas wishing to testify in neutral on the bill? Seeing none, AVH, is there anyone on the line to testify in neutral on AB 589?
Thank you. The public line is open and working. We have no callers for neutral at this time.
Thank you. Would the presenter like to come up and make any final remarks? And that has been waived, so thank you. And I will now close the hearing on AB 589. And I will now open the hearing on SB 161, which revises provisions relating to local government employees. To present this measure, we have Senator Nguyen, and please go ahead when you're ready.
Good morning, Chair and members of the committee. My name is Senator Rochelle. Well, my name isn't Senator. My name is Rochelle Nguyen, and I represent Senate District 3. At the table with me, I also have Daniel Stewart, representing the Clark County Education Association, who will help me walk through any of the details of the bill. Down in Las Vegas, we have Bradley Schrager from Bravo Schrager, potentially to answer any specific legal questions that you might have that might come up with the current law and this law in question. I know Mr. Schrager has one of the few lawyers in this state that has practiced in this area and specifically addressed some of the issues and litigated cases under the current law. With your permission, I'll just give a brief introduction of what this bill does, what my intentions are, and hopefully that will answer a lot of the questions you might have. K-12 funding is a significant part of our budget. In fact, the K-12 education budget is so important that we are constitutionally required to pass it first. Every legislative session, the legislature passes a state budget that has tried to increase funding, increase teacher pay and student outcomes, and increase accountability on school districts. Yet, from my experience and the experience that many of you have heard from your constituents, is that some school districts, in particular Clark County School District, has attempted to skirt the laws that we have passed. And it's teachers and students that pay the price of the school district failures. Over the last several years, we have watched the Clark County School District play fast and loose with the rules, holding back teacher pay that was approved into law by this legislative body, shortcoming capital improvements on things like HVAC system, finding and losing tens of millions of dollars. And SB 161 is a result of watching this same sad story play out over and over and over again. This is particularly meaningful, not just because I have so many Clark County School District schools in my district, but I also have my own children that are in the Clark County School District. In addition to the accountability that we pass into law, one of the best ways to bring balance and power into that accountability to this school district is to empower those at the front lines, our teachers. Over the last decade, the Clark County School District has refused to come to contract agreements with educators, and binding arbitration ensues. Of the last 5 contracts, 4 of those contract arbitrations in Clark County have been into contract arbitrations in the past decade alone. And in those, CCSD lost all 4 of those arbitrations. The problem is a process that is incredibly lengthy and protracted. A decision may take more than a year, and in some cases has taken up to 18 months. So what that means is we as a legislative body approve this budget, approve this funding for K through 12 funding that includes funding for our schools, our teachers, our students, all those programs that you hear about and that you've heard about in this committee and in your committees throughout this building, about special education, about school buses, about school lunches. All of those things are included in that budget, and a lot of times those contract negotiations are being settled on the verge of us coming into the next legislative session where we need to make those decisions. So sometimes an entire school year goes where our teachers aren't getting the pay that we allocated to them as a legislative body. Unfortunately, our current law incentivizes the Clark County School District's methods, leaving students, parents, teachers shouldering the downsides of the impasse. Second, the districts give a reason to, this bill gives districts a reason to reach out. Like I said, this bill seeks to bring back some balance. And I'm not alone in thinking that there's a problem with the current system that we have. We saw, if you're in Southern Nevada and you represent constituents in Clark County, and quite honestly, it's become such a statewide issue that you're hearing it on statewide news being reported that teachers in Clark County are suffering through yet another long contract fight, even as we increased education funding by almost $2.2 billion during the last legislative session. It got so bad that Clark County teachers qualified a ballot initiative that would give all teachers, but only teachers, the right to strike. And unless they choose to withdraw that petition, that will be on the ballot in 2026. The reason I bring up that ballot initiative is that was part of the incentive and motivation for me to bring Senate Bill 161. I don't have any doubt that giving teachers the right to strike would speed up the process. When we look at strikes across the country, there are, I believe, about a dozen states that have provisions that allow teachers the right to strike. Often those strikes only last 3 to 5 days at the maximum. And as you can imagine, if anyone has had children in the school district, we have come to rely on the services of our schools and our teachers, not only just to educate and teach our children, but also to babysit them and watch them and provide food for them and provide services that are very needed. And so I think that's a lot of times why a lot of these strikes happen very quickly. However, I will tell you this, and for those of you that don't know, because it is something that I have learned, not just during the course of presenting this bill, is ballot initiatives are what I call a blunt instrument. If that ballot initiative passes, it goes into the NRS and it cannot be changed for 2 legislative sessions. So that means whatever the language that passes on that ballot initiative, if it was to pass, and it doesn't have to go onto the ballot and be voted by the electorate multiple times, it is one time. So if it passes on the 2026 ballot, it will be in the NRS. And even if there are things that we need to modify and we need to change to implement or to effectuate or correct some of the things, we don't have that ability. When we bring a law, if we mess it up, we get to come back in the next legislative session and take care of that. And unfortunately, with ballot initiatives, you're not able to do that. We are stuck with whatever was passed on the ballot and is in law. What Senate Bill 161 gives us is a more nuanced approach to problem solving and gives us the flexibility as a legislative body to put what we think is important in those policies. Senate Bill 161 not only creates a much faster arbitration, in fact, what I've coined this bill is a right to faster arbitration. I know that you've heard a lot about collective bargaining in this particular committee. I know there's a lot of members on this committee that have been a part of collective bargaining, arbitrations, those. And what you will learn, and what I've learned, is that in a lot of these different industries, whether it's electricians or firefighters, firefighters or police officers, they have an expedited arbitration process. Sometimes that arbitration process is as quick as 30 days and as long as 60 days. But we don't have those same kind of provisions here for teachers in our state. What this does is it gives teachers that same access, and it gives some of that corrective behavior to have a more expedited process. It bumps up deadlines. It makes the process start a lot faster, so teachers are able to get into those contracts. And really what this does is it encourages all parties to mutually agree on an arbitration quicker, much quicker. So we don't end up in a situation where we're striking. There is no strike language in this bill. It has been amended. It was amended in in the Senate. So this isn't have strike provisions in it. So there's still no ability to strike. There are some protections for teachers because what we learned during the during the last year and what the Clark County Education Association and other teachers have learned over the past decade is that a lot of things that we would not consider strike behavior have been construed as strike behavior because of the vagueness of our current laws. Wearing a t-shirt that says Red for Ed could potentially be viewed as a strike provision. Attending a school board meeting in your after-school hours is potentially a strike provision. And this law also gives some clarification to some of that vague nature of the current statute to make sure that our teachers that are doing things that are not considered strike behavior, that are more First Amendment conditions, are not being penalized, with fines or even criminal behavior. And with that, I will turn this over. I want to, just talk about how, in short, this is a law to bring about compromise. Sometimes people don't like compromise. Sometimes it's what about these people? What about this group? What about this organization? Like I said, this is a compromise and a step in the right direction to make sure that we're able to keep our teachers in contract, keep them in the schools where our kids are being educated. And so I know that some people will see this as a criticism of the Clark County School District, but I just want to say that this bill is more than just about one particular superintendent of any one school. I know Clark County Superintendent Joan Ebert, and I know that I want her to be successful. I think her success will make the entire school district successful, and for personal reasons, I want my kids to be in a successful school district. So, and I'm sure that's what we want for all of our constituents that are currently in our public school system. So this brings about some of those structural fixes that go, again, beyond any one person, one union, or one event, and hopefully will help amplify Superintendent Ebert's agenda to bring some competency back to the Clark County School District. And with that, I will turn this over. If you would like us to walk through the provisions of the bill, I'm going to turn this over to Mr. Stewart.
Hey, thank you, Madam Chair. Daniel Stewart for the record, S-T-E-W-A-R-T. During the course of this, if Mr. Schrager down south wants to jump in and add any further details, I would welcome that. Like I said, he has probably the only experience in this space of anyone that I know of in the last few years. Just a couple of preliminary statements before I go through the bill, and I'm going to keep it at a high level because I know where most of the questions seem to be coming from, and I want to jump right to those given the lateness of the hour of the session and see if we can't get right into the meat of the question. But as you heard, this is a bill to attempt to fix some systemic problems with current law that have made impasse, protracted arbitration, and forced settlement the rule rather than the exception when it comes to teachers. Part of fixing the problem is to give the process the urgency it demands, given how entire school years can be lost during this process. And so the way that this bill is set up from a framework is two bookends. On the one hand, you've got the expedited arbitration, which, as I'll explain, that has to be mutually agreed to. This is not something that anyone can unilaterally impose. If the school district and the bargaining agents, the teachers, wish to enter into expedited arbitration, they can. But in order to incentivize that, to the extent that the best is that they just come to an agreement and there's no arbitration at all. But in order to incentivize, if it looks like they're headed towards arbitration, to agree to this expedited arbitration, the second bookend is to take away some of the threats that the districts have been able to use, because once a contract expires and we get into the phase where members are frustrated, they're waiting for the raises that they heard they were going to get at a legislative session, and now it's December, they haven't gotten those raises, that the districts can delay and hope maybe that some individual teachers or so forth will make mistakes and then try to use that as leverage in the bargaining process. So it's the way to take away some of that leverage and clarify who's responsible for what during those process. At the same time, this makes this mutual expedited arbitration more attractive. One thing I do want to make clear, this has been called the strike bill. This is not a strike bill. The strike bill is now the ballot initiative. This is a arbitration bill, an equal bargaining bill. But if this bill passes, strikes by teachers will still remain illegal, punishable by law. In the prior version of this bill, we heard a lot of, in the hearing that took place in the Senate, there had been a provision where teachers could go to court and make a very high showing that a strike was necessary, and if a court allowed it, then a strike could be declared illegal. That has been completely removed as part of the amendment. And we've understood that with that amendment, the governor will sign the bill with that amendment removed. So that's out. So if this bill passes, strikes by teachers will still remain illegal, punishable by law. I want to make that very clear. To begin on the arbitration in sections 2 and 3, which I'm going to cover again pretty quickly, because although it looks like there's a lot of blue in there and a lot of new stuff, in fact, section 2 is already is a definition that's currently drawn from that already exists in NRS 288-217, as well as if you go to section 3, everything from subsection 7 to the end of section 3, that's drawn from the current arbitration process that's set in 288-217. The only difference in those sections is that some of the timeframes have been moved up. So rather than being 30 days, maybe it's 15 days and so forth. But the process, the language of how it works, it's the same. What's new is the subsections 1, 2, 3, 4, 5, and 6 of section 3, which is what allows the parties to start the process as maybe they see as they get ready for an expiring contract. They can actually start the process of maybe getting the arbitration moving if they think that's where it's going to go. And one of those is they start selecting potential arbitrators. One of the things that does delay the arbitration in the education space is you finally agree on an arbitrator. You contact that arbitrator, and the arbitrator, they're national. Oftentimes they work all over. They say the earliest I can get this arbitration scheduled for is February, right? And so you either say no, February is not going to work for us, or you accept and go to a new arbitration, or new arbitrator, or you just wait till February. So this would allow the parties to not only agree on an arbitrator, but to make sure that the arbitrator is pre-agreed to be available to resolve this in time. In fact, the way the schedule's set up, if you knew you were going to arbitration and you did it right away, 75 days before the start of the school year, the way that this is set up is the arbitration should be done before school starts. That's the way this is set up. Now, I want to because there's been a little bit of criticism we've seen about that somehow this arbitration process will maybe make it unfair for teachers to have an expedited process that maybe others don't have. I don't necessarily understand that criticism because, again, this is both parties have to agree to it. If a union does not want to be part of this, they don't have to do it. They can still use the old process. The districts don't have to do it. If they think that it's not going to be fair, they can use the old process. Additionally, under the current system, all the bargaining units bargain separately anyway. So for instance, just in the last contract, CCA began its contract negotiations in March during the 2023 legislature and didn't get resolved until February. It was officially done in February. But during that time, administrators, support staff, all of them got their contracts locked in at different times. So that already exists in law, that the various bargaining units will be functioning on different calendars. This would not change that in any way. This is simply the most complex, I would say, part of this bargaining process is the teachers. They're the largest in employers across the state. This would essentially allow them, again, to move faster. So that brings me to essentially the rest of the bill, which is when I talked about removing some of those negative incentives that maybe the districts would prefer. Well, we like dragged out arbitration because at some point they're going to, like I said, they're going to make a mistake. They're going to do something that's going to get them in trouble, and then we can take them to court. We can file complaints with the EMRB. And so we're removing some of those. So for instance, the first one of those is in subsection 4, which that's the section that says the teachers can no longer be asked, if a contract expires, teachers can no longer be asked to work beyond their contract time, all right? And that's twofold. One, if you don't have a contract, you generally don't want to work when you're not being, for stuff you're not going to be paid. But additionally, not working beyond your contract period if you were asked was often interpreted by the districts as strike-like behavior, right? And so this essentially says when a contract expires, you work what you're paid to work and no more. So again, the district now is like, okay, well, if we want them to work beyond their time, let's get this resolved ahead of time. So again, incentivize the arbitration process. Secondly is cleaning up, like the senator said, some of the terms and some of the punishments. The one that's drawn the most attention has been in subsection 9 about the definition of a strike. And I want to be very clear about what that's meant to do. So it mentions section 9, subsection 2. The term does not include any concerted activity described in subsection 1 that is engaged in by teachers at one or more schools unless the concerted conduct is engaged on a district-wide basis. There's been some discussion that somehow that would allow mini strikes or something by individual teachers. But what I want to make clear is a strike is a very specific thing. A strike is a collective action. If there are individual teachers that decide not to show up to work or to violate the terms of their contract, where a union has not authorized any strike, there's nothing going on, those teachers can be punished. They can be abandonment of contract, insubordination. Any of that activity can be conducted pursuant to the terms of the collective bargaining agreement that the districts and the teachers will raise. So what they're doing is punishable. What we're saying here is it's not considered a strike. And the reason that's important is because what we don't want and what we're trying to protect here is that individual activity being attributed to the union. And that actually happened in real time this last session. You know, not every teacher in the Clark County School District is a member of the union. And some of them don't like the union. And yet the union, in this case, is on the hook, the way the current law has been interpreted, is on the hook for any individual behavior that somebody might do. They decide to, be insubordinate with their boss. They decide to not show up. And now all of a sudden the union is in the risk of decertification, criminal penalties, and so forth. And in fact, on any day in the Clark County School District, 10 to 12% of schools, teachers are not there. They're sick, other things. It doesn't take very much to push that over the edge, and all of a sudden that school is closed, depending on how the district wants to interpret it. And so again, if there is inappropriate behavior by individuals, they can be punished. What we're simply saying is that is not a strike that would then be attributed to the organization. On the flip side of that, if the organization for some reason decided to engage in an illegal strike, the individual teachers then would not be held accountable. The union would, by paying the $50,000 fine a day or the $1,000 fine for each individual officer, right? So essentially clarifying whoever's responsible is the one that bears the blame in this, rather than allowing the districts to pick and choose folks against each other. And Mr. Schrager, I would like to turn it over the time just to talk a little bit about, that's it for me, but just to talk a little bit about what he saw firsthand when it came to how the district would interpret this individual versus collective activity.
Thank you very much, Madam Chair
and members of the committee. Bradley Schrager, Schrager, of the law firm of Bravo Schrager down here in Las Vegas. I would like to focus my comments, if I might, on what I see as the key provision of SB 161, which is regarding the expedited arbitration proceedings. Now, I am an attorney. It is obviously no secret that I make my living in the zone of conflict between peoples and parties. The beauty, the real elegance of this bill is that it doesn't force anyone to do anything. It doesn't force either districts or teachers' unions to make any particular choices. What it does is encourage and set up a context for the possibility of expedited and cooperative arbitration proceedings. As the sponsor mentioned, 4 times in the last 10 years, there has been a declared impasse in Clark County, which required arbitration. Now, 4 times in 10 years doesn't even tell the full story. These are 2-year cycles. So that means there's only been 5 cycles. 4 out of the last 5 contract cycles have seen bitter seasons of arbitration and labor dispute. Currently, those arbitration proceedings take far too long. In fact, last time, had there not been a resolution reached when it was, which even on its own was in December and not ratified by the school trustees until February, it would have eaten up the entirety of the school year. There would have been a full school year of teachers going without a valid new contract. That obviously it impinges upon the school year and instruction because of the stresses that it introduces. Teachers and the school district want to get to the business of educating students, not focusing throughout the year on what's happening with the contract that's supposed to be negotiated prior to the school year and in place so that people can get back to business. But right now, there are no structural incentives to expedite those proceedings. Hopefully, and of course, either side can try and take advantage of the lack of those structural incentives. So hopefully, SB 161's arbitration provisions will foster resolutions of impasses or labor disputes. There's always going to be labor disputes, but it's going to foster earlier resolutions, and hopefully the community will demand that these results and these contracts be resolved earlier. And just by the nature of the structure being proposed here, the notion that long before an impasse can be even envisioned, there should be cooperation on choosing a proceeding, choosing, contacting and mutually discussing with an arbitrator their schedule and the possible issues that may come up. That may foster a context, avenues of cooperation that may in fact lead to resolution prior to having to actually put those into place and go to arbitration. So I think that the main focus, the beauty and elegance of this is to set up voluntary avenues of contract resolution that don't exist now, that hopefully the parties themselves, school districts across the state, the teachers union, and the public will demand be taken advantage of for the benefit of our students. Now, I'm obviously happy to talk about any aspect of SB 61, but those are, in my mind, the sort of key headlines that make this bill so important.
And I think with that, we are, and I appreciate your patience with our lengthy presentation, but if you have any questions, we are ready to stand for those.
Thank you for that thorough presentation on the bill. We do have just a couple of questions, and we'll start with Assemblymember DeLong.
Thank you, Chair. Thank you very much for the presentation. Definitely informative. As it relates to the expedited arbitration, to me, that seems like a good idea. However, I think it's dealing with a symptom and not a cause. The 2 sessions I've been here, all I've heard about are complaints about how CCSD operates. We need to this body needs to come up with a bill that deals with CCSD rather than dealing with the symptoms. So let's just put that on the record. My question has to do with sections 15 and 16. Why is it appropriate to exempt teachers and teacher unions from NRS 288.710 and 715 as the best way to deal with, I think, the issue you're trying to go after?
So Daniel Stewart, for the record, the reason that was drafted that way is essentially the penalties were pulled into Section 7. So it left out two penalties. It left out the criminal penalty, potential criminal penalty, and then the decertification that, again, was being held over the union for potential individual activity. So in Section 7, you'll notice that the penalties that are listed in those other sections, the fines and so forth, those stay in. And then additionally, as I mentioned, the individual, so if the union takes the activity, then the union is punished. If the individuals take the activity, the individuals are punished. And so that was a way to harmonize the penalties.
Follow-up, Chair? So the way I read the additional text you put in Section 15 and 16, to me, it reads that it's exempting teachers and teachers' unions that strike from these provisions.
Daniel Stewart, for the record, correct. But if you look at if the provisions that are being exempted from the specific penalties, so for instance, you have in there the $50,000 a day or the $1,000 fine. If you look at what those specifically are being in, those have been moved forward now in Section 7, where it now says that if a teachers union engages in a strike, it gets the same punishments of $50,000 a day and $1,000 for the individual.
I'm sorry, Chair, I get that, but why is that necessary? Why not just leave 710 and 715 the way it was?
Because of the way that, now, I have the greatest respect in the world for our teachers. I yield in, Daniel Stewart for the record. The greatest respect, I yield to no one when it comes to my respect for the teachers, but history has been the greatest teacher I think we have. And the history has been that the threats of criminal violations or decertification that have been hung over for very vague conduct that could be done by individuals have made it so that the districts want to engage in extended arbitration and hope that they make a mistake. I think Bradley was involved in maybe 4 different cases on this very thing during the last cycle.
I would be happy if I could, Madam Chair, Bradley Schrager, again for the record, if I may speak directly to the member.
Yes, go ahead.
Thank you very much, and thank you for the comment and the set of questions, Assembly Member. I will first say to your first comment regarding symptoms versus causes, I don't think I would disagree with that, but you know, when I'm feeling poorly, when I'm getting sick, I'm always grateful that there are treatments that also alleviate my symptoms. So I'll say that for that. As to the other aspect, I will echo what Mr. Stewart has said, is that teachers unions here are in fact being exempted from 288-705 and 288-715, but they're not being exempted from punishment. And the issue is, I think if I can put a fine point on it, is that if you were going to punish in this example, in this context, if you were going to punish an entire labor union, threaten its very existence for the conduct of individuals, oftentimes unauthorized individuals acting in their own capacity, one ought to be very, very certain that the union is the cause or the reason or the author of that conduct. And the problem is, in applying 710 and 715 to teachers unions, we got away from that principle. And the possibility existed, and in fact was being acted upon, that threatened the very existence of a democratically maintained and established teachers union, which is exactly what teachers unions, all labor unions are, democratic representatives at work for workers. Their existence was being threatened for things that they themselves had no control over and had not authorized. So that was the thought, was that, look, punishment for unlawful conduct is a bedrock concept of the rule of law in this country, and it ought to continue, but it ought to be done in a fair way that doesn't introduce unnecessary, improper, and unfair leverage where the union itself had no ability to control, stop, or authorize the conduct that was being alleged. So that really is where this bill's getting with the re-envisioning of punishments for the organization itself.
Rochelle Lynn for the record. As to your comment, I don't disagree. I think when you look at the breadth of bills that are brought, and I know in particular it may be something that sometimes the issues that I bring before this body in bills are not exactly sexy and can't be in a slogan. But I think it is incumbent on us to look on like the problematic symptoms of like the systems that we have in place and the process that we have in place. You were a part of the legislative body, and I don't know if you voted for it, but it did pass into law to bring about an audit. So obviously, auditing all the school districts is a huge undertaking that our Legislative Council Bureau is currently undertaking. So I imagine when they finish up that later this year, going into the next legislative session, if we're also honored to be able to represent our constituents again in this building, we will have a lot of that data where we can look at where the problems are within our school districts in order to fix some of those like systemic institutionalized problems. And when we come back before you, hopefully we won't need bills like this that fix arbitration problems because we're able to fix the root causes of these problems. So if you have any other questions, I'm ready for those as well.
Okay, thank you. Our next question is from Assemblymember Goulding. Never mind. Our next question is from Assemblymember Kasama.
Thank you, Chair. Good morning, everyone. My question is, well, first, I lived in the district when these negotiations were going on and on and on, and it is such a waste of energy for everyone involved, and the teachers no longer have the time or clarity to focus on the kids and their classrooms and the administrators, and it's just a drain of energy for everybody, and we want people to focus on where those energies should be. So I think this is a really good place to see that this is an arbitration that is very focused, and it speeds up the process. My question is just for my understanding, so we've had arbitration before. We've always had the ability to do that, but there was no timeline. This here, if they mutually agree, there's timelines here. But in the current situation, it just goes on. There's no timeline frame in the current situation.
Daniel Stewart, for the record, that might be a better question from Mr. Schrager.
Certainly. Thank you, Mr. Stewart. Once again, Bradley Schrager, for the record. To the member, that's exactly correct. And in fact, the structure of how it's set up, because you have to go through what are essentially sort of nationalized procedures, finding arbitrators who are available and willing sequentially after a crossing off list. It can take months and months simply to find and settle upon an actual arbitrator. So there is no end date except for, I mean, one would think that there would be public pressure at some point to get to a contract. That has not been the case so far. You could, I guess theoretically, you could take these proceedings through the entirety of the next proposed contract session. I mean, there is nothing in law that says it shall be done by this date.
Thank you. I like the expedited process. Thank you.
Thank you. And our last question is from Assemblymember De Silva.
Thank you, Chair. Again, Senator, I just want to thank you again for bringing this bill. As somebody who was really affected, by this just unacceptable behavior, really, I believe that came from the union. I'm sorry, the CCSD at the time. We had, as a union member, had to get out and really fight to make sure that we got paid properly. After this was resolved, we believed here in the legislative session. My really question was to for the president here of CCA, Marie Nices, if she could come up to the presenter's desk here and just talk about how this really affected teachers going through a process of months now, where we expected a certain benefits, a pay increase, and how it really affected teachers on a personal level during this time of arbitration. Thank you.
Assemblymember, you're asking to bring somebody else up as part of the presentation, and you've got the question.
Yes.
Thank you. Go ahead.
Thank you. Good morning, Assembly members. Assemblymember De Silva. So as the president of CCA, I saw it firsthand. One of my biggest things I want to share with you is teachers do not want to go on strike. Marie Nices, president of CCEA, MARIE-NEIS-ESS. Thank you. We don't want to go on strike. That's not what we're looking for. What we're looking for is a solution. This process is broken. I've been on negotiations for many, many years, and I've seen what it's like to negotiate with the district. And while we're very optimistic with the leadership under our new superintendent, Ebert, the process has been broken for so long that during this time, anytime we're in a contract fight, we lose educators. I go to schools each and every day when I'm not in the ledge session to talk to educators of what things we need to do to improve, and I hear it firsthand. They will not stay. They'll tell me firsthand, Marie, I have to go where I know what my contract is going to be, where I know what I can do for my family, where I know that I can afford to buy a home, where I know that I can afford my health care. So they leave during that time. We started this process months before our contract was settled. What we put across the table was a 22% raise for our educators, months of battles where some of our assembly people and our senators came to join us when we were out rallying. They knew, they heard it from our members directly, only to end up with exactly what we put on the table with a 22% raise. So we want a process that fixes this broken system, because we cannot continue this process because I lose educators and we cannot afford to do so. Thank you.
Committee members, are there any other questions? Seeing none, I want to thank you for your testimony. Thank you for your presentation. And now we will move to testimony. And again, testimony can be provided here in Carson City via video conference in Las Vegas or over the phone, and instructions for providing testimony are available on the agenda. We will begin with testimony in support of SB 161 here in Carson City. Please begin when you are ready.
Good morning, Chair, committee members. Again, my name is Marie Nices, MARIE-NEIS-ESS. I have the honor of being the president of CCEA. CCEA is the only official teacher union recognized by the Clark County School District. We bargain on behalf of all 18,000 educators, and since I put in much of what I was going to say with Assemblymember De Silva's question, I'll keep this brief. Again, we're not looking to strike, we're looking for a solution. In order to respect your time, I just want to put into the record that we did have some educators who submitted public testimony. Danielle Knoppel, who's an audiologist for 17 years, and she's also the chair of our negotiations team. Jim Frazee, a history teacher who's been a teacher for 18 years at Centennial High School. Elizabeth Adler, a bilingual high school teacher who is a learning strategist for 27 years. Matthew Neiswanger, who is a history teacher and coach for 19 years. And Monica Bryant, who is a counselor for over 11 years. Thank you for your time, and we thank Senator Nguyen for work on this bill.
Good morning, Chair Considine, Vice Chair Nguyen. My name is Virginia Valentine, Valentine, and I am here today on behalf of the Nevada Resort Association in support of SB 161. There are over 140,000 Nevadans employed directly in resorts, and the resort industry, as you know, is a very shift-oriented industry. Uncertainty around classrooms, work stoppages, or pauses affect all our employees, our families, very directly. And as Senator Nguyen mentioned, parents rely on schools for education and also for the services provided to children at school. This bill is amended will establish an expedited arbitration process that will minimize impacts to school schedules. We'd like to thank the sponsor, the governor, the CCEA, and everyone who came together with this important measure to better ensure consistency in the school schedule for our children and our families. Thank you.
Thank you. Is there anyone else here in Carson City wishing to testify in support of Senate Bill 161? Seeing none, we will go to Las Vegas for support testimony on SB 161, one of each today. Please go ahead when you're ready.
Good morning, Chair Considine and members of this committee. My name is Angie Joy, A-N-G-I-E-J-O-Y-E. I am a first grade teacher at Mountain View Elementary, an executive board member of CCEA, and the former chairperson of the negotiations committee for CCEA. I'm here speaking in strong support of SB 161. All educators who work hard every day to serve children deserve the peace of mind that a contract provides. I've seen firsthand how CCSD fails to take negotiations seriously, often dragging the process into lengthy arbitration. SB 161 would update an outdated law that currently favors the employer and help ensure that our time at the bargaining table is respected and taken seriously. When our former superintendent tried to use the courts to force CCEA into settling, it brought a lot of uncertainty, fear, and anger from not only educators, but from parents and students as well. Without a contract in place at the start of the school year, many teaching positions went unfilled. New teachers were hesitant to join a district that lacked clear contract terms, especially with the negative press surrounding our failure to reach a timely agreement. It was painful to witness, especially as I saw class sizes balloon at my school due to a shortage of licensed educators. In the end, it was the students who suffered the most from a district that was not fully staffed. This bill will help ensure timely contract agreements by expediting the appointment of an arbitrator and enforcing a clear, efficient timeline for the process. Accountability has been the theme for education this legislative session, and this should be no different. Please support SB 161 to update the laws to reflect fair bargaining in the arbitration process. Thank you so much.
Thank you. Is there anyone else in Las Vegas wishing to testify in support of the bill? Seeing no one, we'll go to AVH. AVH, is there anyone on the line wishing to testify in support of SB 161?
To testify in support of Senate Bill 161, please press star 9 to take your place in the queue. Chair, we have no callers wishing to testify in support.
Thank you. We will then move to opposition testimony here in Carson City. Is there anyone here in Carson City wishing to testify in opposition to SB 161? Please go ahead when you're ready.
Good morning, Chair Considine and Committee. I am Jim DeGraffenreid, JIMDEGRAFFENREID. I'm Nevada's Republican National Committee man, here today in opposition to SB 161. NRS 288.700 was passed in 1969, finds as facts that services provided by Nevada government employees are essential, can't be duplicated from other sources, their disruption is incompatible with the responsibility of the state, every person employed by the government accepts those facts as an essential condition of employment, and that strikes by public employees are illegal as a matter of public policy. We opposed SB 161 when it specified a process that allowed teachers to strike. We find it even more objectionable with Amendment 611. The arbitration provisions are a positive change, but whether it's called a strike or not, teachers being out of the classroom to influence negotiations is effectively a strike. The original bill at least required that the union obtain a court order that a strike was less harmful than some unspecified current condition, but under this version, even that is eliminated. Teacher strikes remain illegal along with other public employees, but sections 15 and 16 exempt teachers who participate in a strike from existing consequences. Section 7 provides that penalties under the law would still apply to union and union officials, but these penalties are not likely to be a deterrent. Penalties are $50,000 a day for the union and $1,000 a day for any union boss responsible for a strike. For perspective, ProPublica reports that CCEA had revenue of $9.27 million in 2023 against expenses of $5.36 million and net assets of over $13 million. Is it possible that a union could consider the penalties in this bill a reasonable investment? We believe that most teachers prioritize the best interests of their students and would prefer to be in the classroom as opposed to on strike, but we don't believe that this legislation provides sufficient safeguards for Nevada's kids. Our students should not be used as bargaining chips in a labor dispute. We believe the only way to protect Nevada students is to leave in place all the provisions of existing law that provide real penalties for illegal strikes, and we urge a no vote on SB 161. Thank you.
Thank you, Madam Chair, members of the committee. My name is Tom Clark. I'm here on behalf of the Nevada Association of School Boards, and we remain opposed to Senate Bill 161. While we really appreciate the arbitration changes, the languages in those sections, the section that still does give us a lot of concern is Section 9, Sub 2, and that is, it may not be called a strike, but a walkout of every school minus one. Therefore, it's not considered a strike because it's not district-wide, is just as disruptive, is just as painful for the community and for the teachers and for the students as a normal strike would be. And so for that reason, primarily, and And if we get some clarification as that's not the case, then we may come around. But the Nevada Association of School Boards remains opposed to Senate Bill 161 primarily on that position that even if it's not the unions telling the teachers to strike, if they're in the middle of their contract negotiations and things aren't going well and half the teachers leave and walk out even for a day, that's just as disruptive. Thank you, Madam Chair.
Thank you, Madam Chair and members of the committee. Good morning. For the record, my name is Dr. Mary Przinski, and I'm here representing the Nevada Association of School Superintendents. And first, I'd like to point out, as Assembly Member DeLong did, this bill, the conversation this morning has been on Clark County School District and the issues there. But the point is that this bill will impact 17 school districts, not just one. And so our superintendents are not in support of the bill for that reason. And as Mr. Clark just pointed out, the concern that the superintendents have at this point is in the section 9 sub 2, which was added in the amendment. We appreciated that the amendment took out section 5, the strike, because keep in mind 37 states do not allow teachers to strike, and we're one of those 37. But a strike is defined in section 9 as stoppage of work, a slowdown, or an interruption of the operation. But when you go down to part 2 or sub 2, it's a new definition for a strike because it says that that everybody, it has to be district-wide in order to be considered a strike. So you have 50 schools in a district, and one school, everybody's showing up, and everybody is on target and teaching their class, and you have 49 schools where there's disruption. According to this, that would not be considered a strike and would not be against the law. So we have a lot of concerns about that. We've expressed our concerns prior to this, and we appreciate working with anyone who wants to work with us on this bill, but this strike area or disruption, stoppage of work, the slowdowns, that's a real concern for our families, for our students, and frankly for our teachers as well. Thank you.
Good morning, Alexander Marks of the Nevada State Education Association, speaking in opposition to Senate Bill 161, which proposes changes to the procedures for arbitration exclusively for teachers' collective bargaining units and would allow work stoppages, slowdowns, or interruption of operations commonly known as wildcat strikes by only teachers at one or more school sites in a district. NSEA represents teachers, other licensed professionals, education support professionals, and administrators in all 17 counties, 16 of which weren't mentioned here today. We believe in fairness for all member types in the bargaining process, and that's what the NAA's Red for Ed campaign was all about, and we appreciate the mention here today. While we would support changes in the law to allow educators to strike, changes that advantage only one type of educator unit in the bargaining process disadvantages other units. The presenters got very cute with their language with regard to Section 9, but let's be clear, this bill redefines the word strike to say that for teachers only, it is not one. This goes for allowing a single group of educators the ability to threaten to strike or strike at a number of locations, as well as moving up the timelines for binding arbitration. 161 is simply an effort to increase leverage at the detriment to every other unit. If only one education unit can make threats to stop, slow down, or interrupt operations at a number of school sites to increase leverage at the table, that will leave less available for other units to negotiate, and the same holds true if that unit can access binding arbitration before any other unit. There is simply no public policy justification why a teacher unit gets access to binding arbitration before an ESP, admin, or even a police unit. We heard the presenters today say that this doesn't provide an advantage and it's voluntary, and if that's the case, why not include all other units? With a new superintendent in Clark County School District, we think this bill will set her up to fail, and perhaps that's the point. During the hearing, the sponsor referenced a measure that is qualified for the ballot that would provide only teachers the right to strike, calling it a blunt instrument. While the bill sponsor may be correct, this is the second time in recent years a ballot measure has been used to leverage this legislative body. This is a good indicator of how the provisions of this bill would be used moving forward. Thank you.
Good morning. My name is Lynn Chapman, and I'm the State Vice President of Nevada Families for Freedom. And we also are worried about Section 7 and especially Section 9. The Brown Center for Education Policy wrote a paper in 2024, and it talked about teacher strikes from 2007 to 2023. There were 772 U.S. teacher strikes. I know we don't have strikes here, however, Section 9 is worrisome. They went on to say the impacts of those actions have been substantial, affecting roughly 11.5 million students and leading to a cancellation of 3,403 school days, or 48 million student days over 16 years. Nationally, the median number of strikes per year is 12.5, resulting in an average of 89 days of canceled school annually. The Education Reporter had an article about teacher strikes around the country, and they pointed out a teacher, Lance Izumi, who is an author and Corette Senior Fellow in Education Studies and Senior Director of the Center for Education at the Pacific Institute. Excuse me, and he says a teacher strike has caused parents to rethink their schooling options, and according to a former educator, the walkout, there was a walkout in Arizona, caused many families to abandon the public schools in favor of charter schools, private schools, and even homeschooling. And while their strike was settled, the students and teachers returned to the classroom. There are those in Arizona and other states who have a different opinion of their neighborhood schools and the school system as a whole than they did before. So many teachers chose to strike. So we have to worry about what is going to be happening. Section 9 gives there's still a problem there. I think the bill has improved greatly, but there still is a problem, so we still are not in favor of the bill. Thank you.
Thank you. Is there anyone else in opposition to SB 161 here in Carson City? Seeing no one else stepping up, we will go to Las Vegas. Please go ahead.
Chair Considine and members of the Assembly Committee on Government Affairs, my name is Anahit Baghshatsyan. For the record, that is ANAHITBAGHSHETSYAN, and I am a policy analyst at Nevada Policy. Today we come in strong opposition to Senate Bill 161. I think it's no secret that Nevadan teachers already enjoy exceptionally broad collective bargaining rights with binding arbitration topics covering sick outs, wages, hours, conditions, work disputes, and much more. Although different from the initial draft and not explicitly stating a right to strike, the reprint one of this bill is equally as dangerous. Nevadan teachers have one of the highest absent rates in the nation's, historically, very, very famously. In 2016, we had the second highest chronically absent teachers in the nation, and we heard today in presentation that every day 10 to 12% of teachers are actually missing their time in the classroom. While condensing the times that the teachers get to arbitrate and have collective bargaining discussions at the table might be useful, I think it also comes with the risk and unintended consequence that now the teachers' unions would have the power to pitbull the school district into a fast-paced and not thoroughly discussed decision, which poses a risk in itself. We need to look no further than Clark County's October 2023 rolling sickouts that have resulted in one-day closures at 8 different Clark County school districts. So adding a legal immunity to strike would make these disruptions far easier to initiate and would inflict academic harm on the very students that the teachers are meant to protect. I think in the presentation today we heard that this is a law about compromise. I would disagree. I think this is a law about a power imbalance. And we shouldn't give power to labor organizations, and I think we should focus more on student achievement, which is what matters the most. Thank you.
Hello, my name is Erica Neely, Neely. I'm a parent, and I oppose SB 161. This bill gives more power to the unions instead of protecting education or our students. The union already has strong collective bargaining rights and binding arbitration in place. Adding right to strike feels unnecessary and risky. We've already seen this impact of disruptions like in the rolling sickouts in Clark County last year. Nevada also has one of the most highest teachers' absentee rates in the county. SB 161 could make these issues worse by accelerating negotiating timelines and giving unions even more power, potentially at the expenses of our students. our children, our future. This isn't about taking sides. It's about putting kids first and protecting our stability of our schools and families depend on it. Thank you so much for your time.
Good morning, members of the committee. My name is Cristiane Mersch, last name Mersch. I'm an ESL educator. I work with the Latino community, teaching English as second language. I fully support fair compensation for teachers, and I believe we should respect and treat teachers as professionals. However, I'm deeply concerned about this bill because we have a big impact in our communities. It will affect 17 districts. Our children will bear the consequences. We have already 37 states that are illegal, including Nevada and Washington, D.C., to be legal, the right to strike for a reason. And here in Nevada, we have a current collective bargain system in our state and is effective and serves as a strong and fair model. Strikes are not the solution. They create a major disruption and bring about serious consequences for our students. Even without the strike right now, local teachers unions, they have the powerful tools to advocate for their interests. And through political organizations, they can work together through actions such as refraining from extracurricular activities, meeting outside school hours, writing college recommendations, or engaging with administrators. Unions can still do significant influence. For the sake of our students and families and communities, please, I strongly urge you to vote no on SB 161. Thank you for your time.
Is there anyone else in Las Vegas who wishes to testify in opposition to SB 161? Seeing no one approach, AVH, is there anyone on the line who wishes to testify in opposition to SB 161?
To testify in opposition of Senate Bill 161, please press star 9 to take your place in the queue.
Cyrus Sajati, Hojjaty. You members of the committee, thank you, Chair. I support our teachers, but this is not the bill to do it. I will yield my time.
Good morning. This is former Assemblywoman Claire Thomas. That's CLARATHOMAS. And I am in full opposition to SB 161. And I would say I would ditto all the remarks that came before me because this is essential for us to express as constituents, as citizens of the state of Nevada, and concerned about our educational system. This is not the way to go. To have strikes. I heard the senator remark about how long a strike would be, 4 or 5 days. It's not in the bill. So is that a guarantee, 4 or 5 days? And 4 or 5 days of missing education in the state of Nevada is a detriment to our students. So I oppose SB 161. And just to also say that I heard one of the presenters say that the reason why non-members are not excited about this bill is because they are not union supporters. And I would say, from what I've heard, that is not exactly true. What I've heard is that they're not happy with union management. So take that into consideration when you are discussing this bill to approve or disapprove it. And I'm hoping that the committee will not bring this for a work session because it is a detriment to our students in the state of Nevada. Thank you.
Chair, we have no additional callers in opposition.
Thank you. We will then move to testimony in neutral on Senate Bill 161. Is there anyone here in Carson City wishing to testify in neutral? Please go ahead when you're ready.
Good morning, Madam Chair, members of the committee. Paul Muratkin with the Vegas Chamber. The Chamber has moved to neutral based off the compromise in the bill regarding the deletion of Section 5. As you know, as a committee, the Chamber has always had concerns about right to strike for our public employees, specifically our teachers, but we do appreciate the efforts by the bill sponsor to address those concerns. Also, you heard from the bill sponsor about the potential initiative petition, and as you know, the Chamber has always had concerns about IPs being used to address policy, and we appreciate those comments that were made as part of that compromise. We do recognize there may be some additional need to clarify some language, but in the spirit of compromise and efforts that have been undertaken by the bill sponsor, the Chamber has removed its opposition and is now neutral on the bill. Thank you, Madam Chair.
Thank you. Is there anyone else here in Carson City wishing to testify in neutral? Seeing no one approach, is there anyone in Las Vegas wishing to testify in neutral on Senate Bill 161? Seeing no one approach in Las Vegas, AVH, is there anyone on the line in neutral testimony on the bill?
If you would like to testify in neutral for Senate Bill 161, please press star 9 to take your place in the queue. Chair, we have no callers for testimony in neutral.
Thank you. If the presenters would like to make any final remarks, please begin when you are ready.
Thank you. Rochelle Wynn for the record. Just briefly, again, part of my motivation is that we spend so much time in this building talking about education funding, talking about accountability, talking about how do we retain teachers, how do we train teachers, how do we get them in there. What we've heard over and over and over again throughout this building is the number one way to have student achievement is to have licensed teachers in the classroom. And when we are not able to get those teachers in the classroom, I think that is a problem. For me as a legislator, it was an interesting position to be in where, like many of you that voted for that $2.2 billion increase, not only to money that follows students, but also for teacher raises to get teachers into the classroom, to have that accountability piece where we had, for those of you that were either on IFC or substituted on IFC, you saw school districts come in over and over again presenting their plans on how they were giving teacher raises. We saw the success of those teacher raises with our special ed teachers and how they were able to take those bonuses and get teachers into those classrooms. I think they were able to fill high risk, high need schools, and our special ed up to 85% in some of these schools where we had shortages of teachers in those areas and in some of those schools. And so I think we will start to see some of the results of this. I think what was frustrating for me is I was going back talking to my constituents, teachers that were working in the school district saying, what did you do for education? And I was able to proudly say, we increased education funding by $2.2 billion. We were able to specifically give teacher raises in the amount of $250 million in addition to those raises that we incorporated into the general base budget. And then to go into the schools realizing that the teachers weren't seeing those raises. They weren't seeing that because of this outdated arbitration process. And so attending some of these protests that were happening after school, knowing that some of these teachers were being penalized for going to school districts, having some of those issues, really brought about the reason that I wanted to bring this bill. I think it will get teachers in contracts in the classroom sooner. Is it a perfect fix? Is there any one bill that will fix anything in our state? No, but I think we do need to make steps to be able to do that. If we had one bill that could solve all the problems in education, we would literally come here with one bill and it would fix everything and we would all sign on to it and we would walk out of here and we wouldn't have to come back for 2 years to fix anything because we had one fix. So, I hope that you see this as the compromise compromise that it is. I know that along with the partners, a lot of the people that were in opposition in the Senate have come to either neutral or to come into support of this bill. I think that is a testament to the compromise, the conversations that we've had. I appreciate the governor's office coming to the table, meeting with me to come up with some compromise language that is before you today that I know he is supportive of. And I would ask for your support of Senate Bill 161.
Thank you, but before you leave the table, we do have one Assembly member who has a question. Are you willing to accept a question?
Of course.
Thank you. Assembly Member DeLong.
Thank you, Chair, and thank you, Senator. Would you be willing to entertain an amendment for a pop cap so that this bill only applies to counties with populations greater than 700,000?
I'm always willing to have conversations about what the bill is. Obviously, Rochelle Wynn for the record. There are a lot of stakeholders that have been involved in this, so it's definitely something that I'm always willing to consider any kind of amendments or suggestions to make the bill a better bill. I will say that I do believe that this is a systemic fix, and if it is a systemic fix that is good for one population, I think it is probably good for the entire population. So I would be hesitant to do that. But like I said, I know that this is a process and it's a very dynamic process. And even though we only have 10 more days, less than 10 more days to go in the session, I'm still open to that. So I'd be happy to talk to you about that further.
Thank you for entertaining the question. Thank you, Chair.
Thank you, and thank you for the presentation and the testimony. And I will now close the hearing on Senate Bill 161. We will take a 5-minute recess, and we will be back in 5 minutes. Thank you. We are back from our recess. And I just want to start with, in accordance with Rule 57-4 of the Assembly Standing Rules, Speaker Yeager has provided approval to take action on the bills heard today within 24 hours of their hearing. And with that, we will go into work session. We will now open a work session to take action on the items the committee heard today. And with that, we will start with Assembly Bill 589. Members, are there any questions? Seeing none, I will now entertain a motion to amend and do pass with the, amend and do pass with the amendment that is on Nellis and was presented today during the hearing on AB 589.
So moved.
I have a first from Vice Chair Wynn and a second from, I heard Assemblyman Member Carter first.
He's very loud.
Yes.
How can no one hear him?
Is there any pertinent discussion on the motion? Assemblymember Kasama.
Thank you, Chair. I really like the intent of this bill. As mentioned during the presentation, I do have some concern with, or not concern, I feel that information is most likely covered already under HIPAA, and that I am concerned for the section regarding the private companies that we could possibly open up ourselves for a lawsuit against the state. So I will unfortunately be no, even though I like the intent of the bill. Thank you.
Assemblymember DeLong.
Thank you, Chair. I am dittoing Assemblywoman Kasama's statements.
Is there any other discussion on the motion? Assemblymember Gurr.
Thank you, Chair, and I ditto those two statements. Thank you.
Okay, is there any other discussion on the motion? Seeing no further discussion, all those in favor say aye.
Aye.
Any opposed say nay. Nay. Please raise your hands. I have Assembly Members Kasama, DeLong, Gurr, Gallant, and Edgeworth as nay. Motion passes, and I will assign that floor statement to Vice Chair Wynn.
Thank you, Chair.
And next, we will move on to Senate Bill 161. Members, are there any questions? Assemblymember DeLong.
Thank you, Chair. I'd like to propose an amendment to this bill to insert a population cap so that this only applies to counties with populations greater than 700,000.
Thank you. While I appreciate the suggestion at this time, I prefer to move the bill as the committee heard it today. So if there are no other questions, I will entertain a motion for Senate Bill to do pass Senate Bill 161 as we heard it today. And I have motion first from Vice Chair Wynn and second from Assembly Member Hunt. Is there any discussions on the motion? Assemblymember DeLong.
Thank you, Chair. Again, without amendments, I can't vote for the bill as it currently stands. I think it needs amendments to be applicable to the entire, if it's going to be applicable to the entire state. So I'm going to have to be a no.
Thank you, Chair. So I'm going to vote yes out of committee, but I'm going to reserve my right. I just have I have issues with Section 9, and so I hope the stakeholders can work on heavily amending it or omitting that part, but I will vote it out of committee today.
Is there any other discussion? Assemblymember Kasama.
Thank you, Chair. I will be voting it out of committee as well. I would like to add to my colleague's comment to Section 9. I hear the concern in that section, and if there's something that could be considered with the floor amendment as to maybe a percentage of the schools or something like that, I would like to see some work being done on that to bring more stakeholders in. Thank you.
Assemblymember Edgeworth.
Thank you, Chair. I will vote yes to get the bill out of committee, but reserve my right.
Is there any other discussion on the motion? Assemblymember Goulding.
Thank you. I also am going to vote supporting this out of committee, though I have some serious concerns and hope we can continue the dialogue.
Is there any other discussion on the motion? Seeing none, all those in favor say aye.
Aye.
Any opposed say nay. Nay. Please raise your hand. I have Assembly Members Gurr and DeLong. Motion carries. And I will assign the floor statement to Assembly Member De Silva. With that, we will close the work session and move on to our last item on the agenda, which is public comment. Public comment is not an opportunity to rehear testimony on a bill, and we ask that you please keep your public comment to the topics within the jurisdiction of this committee. As a reminder, members of the public can provide public comment in person or telephonically and may submit public comment up to 24 hours after the meeting. Instructions for providing public comment can be found on the agenda. If you would like to comment telephonically, dial 888-475-4499. When prompted to provide the meeting ID, enter 813-7531-9802, and then press pound when prompted for a participant ID. Participant ID. Each person will have 2 minutes. Please clearly state your name and spell your name for the record. Is there any public comment in Carson City? Seeing none and seeing no one in Las Vegas AVH, is there anyone on the line for public comment?
If you would like to provide public comment, please press star 9 to take your place in the queue. Chair, we have no callers wishing to provide public comment.
Thank you. Members, please keep an eye on the committee agendas moving forward. If more business comes before the committee, we will be back to carry out the remainder of our work. But that does conclude our meeting for today, and the meeting is adjourned.